and we are live.
Hello, everyone. It's good to be with you. My name is George Housen. I'm an attorney with Legal Aid of North Carolina, and I'm the director of that organization. Today, we're going to talk about the CARES Act and COVID-19 and the benefits and programs that come under the CARES Act and that you might be eligible for and that you need to know about. But first, I'd like to start and talk just for a few seconds about Legal Aid of North Carolina. I want everyone to know that first of all, we're not a state agency, so we don't do criminal work. We can't help you with your traffic ticket or anything like that, but we're a statewide nonprofit agency, a statewide nonprofit law firm, and our practice is a civil practice. And that means we focus on things like housing, landlord-tenant, family law, especially domestic violence, public benefits, food stamps, those kinds of things, Social Security. Consumer, we do foreclosure work, we do consumer protection, fraud work, employment work, we do unemployment insurance, and that'll be one of the things you hear about today. We do work with education and community economic development. And in addition to that practice, we have special projects in which we work with seniors on a wide range of issues for seniors. We work with veterans. We do a significant amount of disaster relief. As I said, we do foreclosures. So anything that's related to civil law, if you have an issue with that or you have a question about that, by all means, feel free to call us, email us, and we will be happy to help you with that. And in terms of calling us, let me give you the number right away. I know you'll see this elsewhere, but 1-866-219-5262. Again, 866-219-5262. That's our call center number, and we can get you then to an attorney and to someone who can help you with any question or legal problem that you might have. And if you wanted to visit us, we're at www.legalaidnc, all one word, legalaidnc.org. And you can find us there. But we're here about the CARES Act. And the CARES Act, of course, is the Coronavirus Aid, Relief, and Economic Security Act that was passed by Congress. I have a copy of it right here. It's over 300 pages long. You're certainly welcome to read it, but I say, why read it? Because we have experts here. We have a staff of 400 of the best attorneys, paralegals, and support staff people in any law firm in the country. And the Coronavirus Relief Act, the CARES Act, was passed back in March. And these excellent lawyers and paralegals now have had 3 months to read the thing, and they're full of information that they want to share with you. So if you have a question about any part of the CARES Act, a program, whether you're eligible for benefits, how it covers you, what the impact will be on landlord-tenant issues, on public benefits issues, unemployment issues, you need to call us again at 1-866-219-5262 and pay attention to these forums. We will be covering the entire gamut, the entire range of CARES Act programs and benefits that you may be eligible for and that you should educate yourself about. With that, I'm going to turn it over to John Keller, and he'll take care of the rest of the program. So stay healthy, stay strong, and give us a call if you need us. Thank you.
Great. Thank you very much, George. My name is John Keller, and I'm a staff attorney with Legal Aid of North Carolina. I work out of our Wilson office. I want to talk to you for a couple of minutes this morning about the unemployment benefits that are available through the CARES Act that George mentioned. The unemployment benefits are administered in North Carolina by the Division of Employment Security. Applications can be done over the phone or online. I'm sure folks have heard about the real difficulty getting in on the phone right now. Although DES, Division of Employment Security, has more than doubled its staff, right now it still appears that folks are not having a very much success getting in on the phone. So applying online seems to be your best bet. And that website is www.ncdes.gov. And you can set up your own account and put in your application for benefits. The CARES Act created 3 brand new unemployment benefit programs. So I just want to briefly describe what those 3 programs are. The one you may have heard about most is PUA, and that stands for Pandemic Unemployment Assistance. And these are for folks who ordinarily would not get unemployment benefits under the state unemployment system. These are people who are independent contractors, people that own their own businesses, people who may have just been part-time workers and didn't build up enough wages in the unemployment system. All of you are now able to apply for unemployment benefits if you are out of work or if you have reduced hours because of the COVID-19 pandemic. One thing to keep in mind, the PUA application, it's supposed to be processed based upon your sworn statements that you are submitting online. We have been in contact with DES about some potentially confusing and misleading information on the website. Specifically, the website says that you should gather up all of your proof of wages and proof of medical documentation if you're out of work because you have the virus. And it tells you to try to do all that before you apply. That language is supposed to be getting removed shortly. The PUA law says that you can apply based upon your own sworn statements and verification can be gathered later. The next program that just got up and running a couple of weeks ago is called PEUC. And this is the extension on state benefits. So if some of you were drawing unemployment benefits under a regular state unemployment claim and you had a maximum of 12 weeks of benefits, well, those benefits may have run out in January, February, March. And if you are still unemployed, PEUC is the program where you can get up to 13 weeks of an extension on that state unemployment benefit claim. So again, you would go to the same ncdes.gov website and put in an application for PEUC benefits. Some folks may have been told over the past few weeks or month, well, PEUC has not been set up yet. Why don't you put in an application for PUA and it'll just sort of transfer over to PUC when PEUC gets running. Unfortunately, that is not correct. And so DES is supposed to be notifying folks that were turned down for PUA because what they were really trying to do was to get an extension on an expired or exhausted state claim. Even though DES is supposed to be contacting you, get back on the website and get an application in for PEUC. If you're one of those folks that had a state claim and you used up all 12 weeks and now you're able to get an extension. The last thing I'd like to mention briefly is a lot of folks are now getting called back to work. The economy is reopening. Companies are saying, your job is available, come back. One thing, some folks have been drawing a pretty generous unemployment benefit. There's been this $600 extra payment on top of your underlying unemployment claim. It may be that your unemployment benefit plus that $600 benefit was more than what you may have been making. Unfortunately, you cannot say, I'm not going back to work, I'd rather draw unemployment. You got to go back to your old job. However, people have legitimate concerns about whether or not their old job is safe. And you have a right to ask your employer what safety measures are in place. If you were working, say, in a retail establishment, what's the rule about masks, plastic guards for cashiers, distancing in the store? Employers should be, although it's not legally required, but employers should be following CDC and other guidelines for a safe workplace. And so if you've got concerns, you have a right to ask your employer what they're doing to make your workplace safe. Also, if you continue to have to, if you're quarantined yourself for COVID, if you're taking care of someone who has COVID, and if you've got children that are at home that you need to take care of because daycares or schools are closed because of COVID, those could also all be reasons why you may not have to go back to work right away, right now. If you've got any questions, feel free to look at the NCDES website. They've got a Q&A about returning to work, and it's actually a pretty good one. Although like I said, we've got some concerns about the PUA questions, making it seem like you've got to gather all your information first before applying, which I'm saying is not correct. They do have a good Q&A about these are some reasons and questions that you may want to raise before you are make your decision to return to work. But keep in mind, if returning to work is reasonable and you refuse to go back to work, you may face your unemployment benefits being cut off. Those are a quick few facts about what's happening with unemployment over the last couple of weeks. Feel free to contact Legal Aid of North Carolina with questions. Thanks a lot.
Thanks so much, John. Now we're going to turn it over to Gigi Warner.
Great. Thanks, Hannah. So I'm not going to be speaking about the CARES Act, but I am going to be speaking about domestic violence in the time of COVID. My name is Gigi Warner, and I'm a staff attorney on the Domestic Violence and Family Law team in the Durham Legal Aid Office. So I'm going to start by talking about what is the domestic violence process right now in North Carolina, and then give a few extra tips about things to think about during this time. So first of all, I want to say that agencies are open. So police departments are open, the sheriff's department is open, the courthouse is open, legal aid offices are open, and most domestic violence agencies in local communities are open and operating, not necessarily open for walk-ins, but are running their 24-hour hotlines and are assisting community members. So please know that those service agencies are open and operating. Next, I want to go into the process of what it looks like to file for a restraining order. In North Carolina, it's called a domestic violence protective order. So there are a few areas in North Carolina, depends on your county, if you can file electronically. And what that looks like is usually you go to your local domestic violence agency and will file for, you'll fill out the paperwork and an advocate will assist you, and it'll get submitted electronically, and then a judge will get that paperwork and review it and possibly do a video conference with you to ask additional questions and make a decision about whether to grant you a temporary protective order. But not all jurisdictions have that. And so you may need to go to the physical courthouse in order to go through that process. So the best thing to do is going to be to call your local agency. And in order to find out the number for your local agency, you can either call the National Domestic Violence Hotline, which has been posted, or you can go to the North Carolina Coalition Against Domestic Violence website, where they list by county each agency. And so those advocates are going to be able to tell you which place is running and where you can get that help. So if you do need to go to the physical courthouse, there are a few things that you need to keep in mind based on COVID. So the first is that it's going to be important to try to leave your children at home if you can arrange for alternate childcare, and that will be really helpful. The courthouse is trying to limit the number of people that are in the building as much as possible. So if you can leave children and other people that you would maybe normally bring for moral support, that will be really helpful if you can leave those folks at home just to reduce the number of people in the courthouse. Of course, if you need to bring a witness who you want to speak to the judge about what's happened, then that is perfectly fine. The next thing is that you're going to need to wear a mask. Most courthouses are heavily encouraging, and some are requiring that you wear a mask that covers your nose and mouth in order to enter the courthouse. So please do bring that with you. And then the courthouses are usually, I think almost all of them now, are taking temperatures before you can be allowed into the courthouse. And they're going to ask you a few questions about whether you're experiencing any symptoms or whether you've been exposed to anybody who has the virus. And once you're inside the courthouse, we ask that you please try to maintain social distancing, understand that your attorneys or advocates, the other people in the courthouse are going to be trying to maintain social distancing, and we ask that you do as well for both your safety and theirs. So if you are needing to file for the protective order at the courthouse, what you're going to do is fill out the paperwork and submit it to the clerk. And then the clerk is going to get you in front of a judge, and the judge is going to either review the paperwork or they may also want you to give testimony and ask you a few additional questions and hear from you more about why you want this protection. And so they're going to then, based on what they read and what they hear from you, whether to grant you a temporary protective order. And then at that time, they're going to schedule you for a return hearing within 10 days to return to the courthouse and have a more full hearing based on the protective order to determine whether you are eligible for a 1-year protective order. So that return hearing will be scheduled. And between the time of that initial hearing and that return hearing, the defendant is going to need to get served with the paperwork. So the defendant is the person who you have filed this against, the person you want the protection from, and they are going to need to get notice of that you've initiated this case and that there's this new court date coming up that they are involved in. And so they have the right to know about this and appear at that hearing. So it's possible in your jurisdiction, that in your county, that the court will hold that return hearing remotely. And so you're going to need to talk to, again, the advocates at your local agency. And if you are able to get a legal aid attorney, they will let you know what that process will look like. I'm not going to go into what a remote hearing looks like, but that is possibly going on in your county. So if the defendant, if the other party has not been served with the paperwork by the time of that return hearing within those 10 days, then the judge is going to have to continue the case. And that's just, again, because the defendant needs to have notice of the case. And if they haven't been served with the paperwork, then the judge has to continue the case. And so it will likely be continued for about 2 to 4 weeks, depending on where you are. And that temporary order, if you were granted a temporary order in that initial hearing, then that will be extended and kept in effect until that next court date. And it's the sheriff's office's obligation or responsibility to serve the defendant. So they're going to look at the addresses that you provided for that person, either where they live or where they work. And they're going to use the information that you provide about their whereabouts and try to find them and get them served with that paperwork. So if you need a continuance, if you are unable to attend that return hearing, or for whatever reason you need that court date to be moved, then it's important that you call the clerk's office and let them know that you can't make it, or if you have a legal aid attorney, that you let them know that you need it to be continued. And judges during this time have been very flexible with continuances for the most part, not everywhere, but it's going to be you need to communicate that to someone. You shouldn't just count on there being continuance if you don't show up. So be sure to be in touch with the clerk's office. And if the defendant has not been served yet, then it may mean that you will be excused from attending that return hearing, since we know that it'll be continued anyway. And so it's, again, important to be in touch with the clerk's office or your attorney to make sure that you know whether you need to be there that day or not, or whether your presence is excused. So let's say that the defendant does get served in that time period and that you don't need to ask for continuance ahead of time. And so you plan to go to that return hearing and have your case proceed. So there are a few different things that could happen that day. The first is that the defendant could not appear at court. They could, even if they received the packet and they know that you have a hearing to talk about a restraining order against them that day, They may just decide they don't want to go, and that's fine. And so in some jurisdictions, in some counties in North Carolina, judges are still continuing those cases, just out of an abundance of caution, or for local court policies, they're deciding that those return hearings are being continued. But in other counties, those cases are going forward. And so you can be prepared. And again, so you just talk to your local agency and talk to your attorney. But it's possible that as long as the defendant's been served, you can go into court and get that case resolved that day. And what that looks like is you will need to give testimony. And if you have an attorney, that attorney will assist you by asking you a series of open-ended questions to help explain to the judge what happened, how it affected you, and why you want this protection. And if you have any evidence, they'll help you present that. And then the judge will make a decision about whether to grant you that 1-year order or not, even if the defendant's not there, as long as they have verification that the defendant was served with the paperwork. And then, so if the defendant doesn't appear. If the defendant does come to court for that next court date, then there are a few different things that could happen. One is that the defendant could request a continuance on their end for any number of reasons, like they want to get an attorney, they want more time to prepare, whatever it is. And my guess is that that will most likely be granted. And so if it's the first time everyone's there together and the defendant wants to request a continuance, that is a possible thing that the judge will grant. The next thing that could happen is that the defendant could agree to what you're asking for. So if you have an attorney, the attorney could speak with the defendant, or if they have an attorney, speak with them and see if they're willing to agree to stay away from you and not have any contact with you and agree to all the things that you're asking for. And if they do, then the defendant will sign an order and you will sign an order and the judge will sign the order, and there will not be, because there won't be a hearing, there won't be testimony or evidence submitted, the judge will not make what we call findings of fact, meaning that the judge will not make any formal findings on the record that the defendant did anything on any set date, but that they are agreeing to enter into a court order that says they're not allowed to come near you or have contact with you. And so that order will get entered for the 1-year period, or however long you agree for it to be in effect, up to 1 year. And then that's it. You won't need to testify or do anything else. That order will be entered. If the defendant does not consent and for whatever reason doesn't want to agree to the terms, then you'll need to have a hearing. And so it may again be continued for if the court's calendar is too much that day, or for whatever reason it may end up getting continued. But if everyone's ready to proceed, then you'll go ahead. And so again, if you have an attorney, that attorney will assist you. You will give testimony and talk about what happened, again, how it affected you, why you want this protection. You can submit any evidence that you may have. And then the defendant will get to testify, and then the judge will make a decision. Any witnesses who you want to testify, you can as well. And then the judge will order either the 1-year order or deny the request for protection. So that is the overall court process, and we could go into a lot more details, and we'll have another video about what all the forms of relief are, about all the things you can get in a protective order, but I'm not going to talk about that right now. So I'm just going to go through a few extra tips that I think it's important for folks to know about during the time of COVID. So you heard I didn't mention the virus at all really during the last 5 to 8 minutes, because this process really hasn't changed much during the pandemic. Domestic violence court cases are in a lot of jurisdictions proceeding like normal. They may be remote, they may be getting a lot more continuances, but for a lot of, other than everyone in the courtroom wearing a mask, this really has not changed much. And there have not been any federal law changes related to how domestic violence courts are operating, except for the fact that they could be done remotely on your phone or on your computer. So a few other notes. Again, I just want to reiterate that sheriff's offices and police departments are open and operating. If you need to call 911, officers will respond. If there is a party who has had criminal charges and you want to follow up and learn more about what's going on with those charges, call the police department. You may not get a live person on the phone right away, you may need to leave a message, but they should get back to you. So please don't hesitate to call those offices. All of those agencies are working full time. And similarly, if the person who has been harming you was arrested and has a criminal court date, then you can call the district attorney's office in your county and get more information about where that person is, about what their court dates are, and whether you need to be present at those court dates. So when someone is arrested, they are then scheduled for a first appearance and bond hearing. And the victim of that crime has the right to be present at that hearing. And so victims often aren't notified about those first appearances. But if you call the district attorney's office, they can let you know when that is scheduled and whether you're able to be there. And so, because the judge will be deciding whether that person could potentially be given a bond to be released from custody. And so again, if you call the district attorney's office with questions, just you may not get a live person, but leave a message and they really should get back to you. Similarly, domestic violence agencies and shelters are for the most part operating. So I know that there are some local shelters that have shut down during this time, understandably, or are operating on a very limited basis. But otherwise, I know that there are places that are operating. Shelters are attempting to do emergency hotel placements for folks who need emergency housing. So please don't think that those agencies are just shut down right now. They are absolutely operating. And I know that 24-hour hotlines are still operating. And okay, I just want to say a few words about online harassment, since we're all on our computers and our phones and we're working from home for some folks. So I just want to say a word that, please, if you are suffering from online harassment or electronic harassment, please, first of all, report that to law enforcement if you're comfortable. That is a crime in North Carolina. And please keep the records. Please take screenshots. Save files and document and preserve that evidence, because it really can be used later for either a civil domestic violence protective order case or for a criminal case if you choose to report to police. And similarly, for preserving evidence, I like to recommend that folks log any instances of domestic violence, any instances of abuse that they're suffering. This is a stressful time as it is, and it's a lot more stressful if you're experiencing violence in your home. And so if you're able to safely do so, we recommend that you keep a log of dates and descriptions of what's been going on. Similar to on the online front is surveillance. So I want to just say a quick word that if you think that the person who is harming you is capable of monitoring your devices and how you're using your technology, please do some digging into how you can protect yourself and make sure that your devices are not vulnerable to monitoring by another party. I would recommend going to womenslaw.org, and they have great resources about how to keep yourself and your technology safe from domestic violence abusers. And lastly, on that topic is, I know that we have a lot of children at home who are using devices now more than ever. And so I want to just give a quick warning to try to keep an eye on children using devices, entering platforms where there could be chat functions with other users of that platform, because we want to look out for any predatory behavior towards children during this time, since folks know that many of us are operating on our devices right now. And so I would recommend sharedhope.org as a resource for parents to help make sure that their children are safe when using technology. I next want to mention that during this time, we've seen an uptick in abusive landlord or employer practices. So if your landlord knows that you're having trouble paying your rent and they suggest that you engage in an intimate relationship with them or commit sexual acts with them in order to not have to pay your rent or anything like that, that is absolutely against the law. And you please call the legal aid helpline and possibly the police if that's happening to you. There are absolutely resources to protect you from that, and that should not be happening. And same with employers. If your employer is saying, I'll only give you your paycheck or only give you hours if you engage in a dating or sexual relationship with me, then that is unlawful, and you should please call the helpline for advice about how to handle that. Couple last things is custody orders. If you have a custody order in place for your children, during the pandemic, we received a lot of questions about whether folks should continue complying with those, or whether all those rules are thrown out the window. You know, you don't want to exchange your children with someone in another household. But the governor's order did specifically accept, it created an exception so that custody orders should still be followed as much as possible. And so if you need any legal advice about your unique situation, please call the legal aid helpline to get answers to your specific questions. But we do recommend in general that you try to keep complying with those provisions and those exchange times. And so the last thing I'll say is just a note on mental health. This is incredibly stressful, and this pandemic has brought about incredible, mental health burdens on everyone. And if you're in an environment where you're experiencing domestic violence in your home, then this is, quadruple times more stressful and tough on your mental health. So please do look for resources related to that. There are great national hotlines, and your local agency hotline can absolutely refer you to local mental health resources if you need it. And so please know that you're not alone. There are so many people who are here to help you and ready to serve you. You just have to pick up the phone. So please call, and thanks so much.
Thanks so much, Gigi. And thank you for watching this Freeform Friday. We have a lot more resources on our website that you can find at legalaidnc.org. And we'll be back next Friday at 11 a.m. and we hope to see you there.